Hi, this is Kevin Bommer, CML Deputy Director, and welcome to the last installment of the CML Video Statehouse Report during the regular session. We'll do an update sometime down the road here after the dust has settled, talking about what happened. Do want to point out that as of today there is a new CML Legislative Matters blog that has been posted, sort of summarizing the home stretch of a few key issues in the legislative session. Talk about some of those in the Video Statehouse Report here, but if you've not been there before, it's legislativematters.wordpress.com, and there's a bunch of our previous blogs on there as well. I'm going to talk about a couple key issues that are here in the last days of the session of municipal interest. My colleagues will talk about some that they're working on. Probably the biggest thing that happened yet today was Senate Bill 243, which is what I've described as a beer and liquor omnibus bill, following up on Senate Bill 197 from 2016. This is legislation that is aiming to put in place some new language as it relates to fermented malt beverage licenses being able to sell full-strength beer starting on January 1st, 2019. As with a lot of these types of bills, there are a whole lot of other things that are in there as well. Some things that CML has worked on, like an update to alcohol beverage tastings, clarification of the ability of local governments to allow public consumption in parks, for example, and a few other things. But the crux of the bill is aimed at saying who can and who can't, and how they can and can't sell full-strength beer starting on January 1st, 2019. It mainly affects convenience stores and grocery stores that have fermented malt beverage licenses. CML's neutral on the bill. There's language in there that we secured. We thank the proponents for working with us on that. That ensures that 500 feet from schools will be the maximum distance or minimum distance that a new fermented malt beverage license can occur. Of course, like with any other liquor license, the local government can waive or even reduce those distances or exempt certain educational institutions from being counted. So that local government part of the bill is really in good shape, as well as a commitment from the proponents, which happened today, and an amendment to reduce a restriction on municipal and state ability to accept fine in lieu of suspension and capping those fines. That's out of the bill now. So it's really now an industry versus industry battle that's going to probably go all the way up to the end of the session. Today's committee hearing here in the second House, it's in the House of Representatives now, was something like I've never seen before. I'll just leave it at that. So that is beer and liquor, and you'll have to check out our written Statehouse Report copy and the after-session video Statehouse Report, and we'll tell you how it all turned out. The other thing I'm working on is PARA, Public Employees Retirement Association, is not buttoned up yet. This is Senate Bill 200 that would help restore or eliminate the unfunded liability over a period of 30 years. There's 27 member municipalities in the local government division, and as of now we've been able to keep them with no additional employee or employer contributions, even with all the other reforms. That's because the local government division is much better funded, needed not quite the same patch that the other divisions have needed. But that bill's going to a conference committee that'll have to meet and figure it out before next week. As of today, the conferees have not even been named yet. There's politics around everything, but we expect that to start moving forward soon.
Hi, this is Morgan Cullen with the Colorado Municipal League, and I want to give you a quick update on transportation infrastructure funding. Senate Bill 1, which had already passed the Senate, was heard before the House Transportation Committee yesterday, and it passed with a strike below amendment. The amendment does a number of different things, but it provides additional $495 million in state transportation funding for this fiscal year, an additional $150 for the 2019-2020 fiscal year, and then it also offers voters a chance in 2019 to consider a referred measure for bonding up to $235 billion in bonding for state infrastructure. So that's basically what the bill does. The reason it's in 2019 is to give voters in 2018 an opportunity to initiate a citizen-led ballot question for 2018 that may include new state revenue. So that's essentially what the bill does. CML has moved from neutral to support on Senate Bill 1. We've been closely monitoring the bill all session long, but until now, the bill did not offer a statewide solution with a local share back to local governments. This is a statewide problem, and local governments have just as many challenges in transportation infrastructure funding as does the state. This bill, however, as amended, provides significantly new transportation revenue to local governments, and we are wholeheartedly supportive of the effort going forward. We think there's going to be, I know there's going to be a lot of amendments as the bill moves. It passed House Finance this afternoon. It's going to be heard in appropriations next, and then it's going to go to the floor for second reading. I know there's going to be significant changes to the bill, and there's going to be a lot of amendments that are put forward, but CML is going to work very hard to make sure that there is a local share back component within Senate Bill 1 when it passes. So that is what we are going to be working on very hard until session adjourns next Wednesday.
And just an add-on to what Morgan just talked about, and when he recorded that, the things were still in motion. Things happened fast in the last days of the session. There is a deal in the works on Senate Bill 1 that looks like it would deal specifically with the referred measure in 2019 if a citizen initiative in 2018 doesn't pass. Originally, there was talk of trying to include municipalities and counties in on the bond revenue that if that question were to pass. That ended up being not as great a deal as it looked like, as we would have had to contribute HUTF money into that in order to get bonded revenue back. And as it turns out, for every dollar that we put in on the municipal side, we get 50 cents back. Not a good deal, and we asked to be pulled out of that, which works out well for the state, which will have more money for it, about 85% of the overall revenue if that question were to end up passing. And then the other 15% would go to multimodal, which we would get a share of that. Very complicated, very tricky, a lot of moving parts here late in the session. It could change again, but Senate Bill 1 will be on the House floor tonight on second reading, and by early next week we'll go back to the Senate for concurrence.
Hello, this is Dianne Criswell, CML Legislative Counsel, and I'm already looking down at my notes. I apologize, folks out there. I've got the kind of update that you see at the end of session, which is we're starting to see bills fly through, and some of them are dying. So let me start with one of the bills I've told you about is House Bill 1383. We were neutral on this bill. It would require construction bonds for P3 projects, and it died in Senate Finance. Today, a couple of bills that we supported made it out of Senate third reading. That's the second house for these bills. So they'll shortly be headed to the governor for signature. So those bills are House Bill 1190. This is the reauthorization of the Main Street Revitalization Act. So those are the tax credits we use to help provide resources for historic preservation. Then 1234 is the clarification of gambling bill. This was amended in the Senate committee to allow a little bit of a safe harbor for some of the folks that had had enforcement actions taken against them. But the clarification is going to apply in the future, and we had some great testimony from our friends in Parker, Cripple Creek, so glad to see that bill make it out of the Senate and on the way to the governor's office. The next bill I'm going to update is, we'll find out what happens to this bill this afternoon. This is House Bill 1404. I've talked to you about this before. It's the making internal investigations of, these are internal affairs investigations of peace officers, making those, which are now subject to records requests for inspection under the Criminal Justice Records Act, making those more open. So the bill as introduced was caused us quite a bit of concern because it really broadened the scope of those files being accessible, and kind of raised a lot of legal concerns. So when we talked last, the bill was being held over on second reading. They did do second reading earlier this week, and the sponsors significantly revised that approach. CML, we still have some outstanding issues that we'd like to see clarified, but we did remove our opposition because the approach went from making the summary of the IA very accessible, and then if that didn't satisfy, making the whole file accessible, and then redacting only specific kind of information. That was the approach as the bill is introduced. The approach of the bill as it left the House was to require custodians to take an individualized look at those files and to follow some of the balancing tests that are set out in case law to help gauge the public interest in having accessibility of the file. So that bill is up on second reading in the Senate, not second reading, is up in the committee of reference in the Senate, it's been assigned to Senate State Affairs. And that'll be up this afternoon after the Senate finishes on the floor, and they're still going, and it's a little bit before 3 right now, so we'll see what happens. So as far as Senate bills, Senate Bill 233 was the omnibus elections update, primarily for Title I. There are 4 timelines related to coordinated elections that municipalities will need to synchronize, so keep your eyes peeled for that. But it has made it out of the Senate. It'll be on its way to the governor's office for his signature. The last bill that I have to tell you about is Senate Bill 247. This set up a program at its introduction for police and fire to contribute to a fund that was administered through the state treasurer's office to pay for continued benefits for dependents and the surviving family members of an officer or fireman who died in the line of duty. We were neutral on the bill, again, to remind you. This is likely something that we've got some members that are already doing. These line of duty deaths are way too frequent, but they are not so frequent that we elected to support the bill as an outstanding and really large and unavoidable cost. But we appreciate the sponsor's intent and can certainly understand for those families that have lost a family member. This is something that they were very interested in doing. It was amended as it worked its way through the legislature to expand it to all law enforcement, not just police, but to include sheriffs and similar law enforcement peace officers that work for local governments. So that bill has passed both chambers and is on its way to the governor as well.
Hi, this is Meghan Dollar here with the Colorado Municipal League. I'm going to start out with some updates on some municipal court issues. I'm extremely pleased to tell you that House Bill 1353, CML's initiated legislation to fund the unfunded mandate from HB 161309, passed the Senate today on third reading and is now going to be sent up to the governor to be signed. Another piece of municipal court legislation that I want to talk about is Senate Bill 203. That has to do with conflict-free defense counsel in municipal courts. This bill was worked on with stakeholders in the interim, including CML, and CML did ultimately go neutral on the introduced version. 203 did take many forms throughout the process. Ultimately, the Senate did concur in House amendments that did keep the bill as it was introduced with some changes that CML asked for, which kept our neutrality, and that bill was ultimately passed. Another bill to talk about is in the limited gaming realm. That is Senate Bill 191. What Senate Bill 191 does is increase what the state puts into the local government limited gaming impact fund. Right now, the fund is capped at $5 million, and what this does is index for inflation, ultimately providing another, hopefully, upwards of $200,000 in the fund annually. Currently, there is some opposition from House leadership, and CML and CCI are hoping to work with the House leadership to get that bill passed and continue working on that important funding mechanism for our cities and towns.
So again, this is the last Statehouse report of the legislative session. We do intend to do a wrap-up sometime after the dust settles, and we can talk about what's on the governor's desk, things that passed that are important of municipal interest. You can track that on the CML webpage on the links provided in the Statehouse report. And then after we get all of the action from the governor on bills sometime later in May, into early June sometimes, then we'll publish CML's Laws Enacted, and that will appear on our website. It's an online publication available for anyone to download that highlights the bills that passed. So it's been our pleasure to provide the video Statehouse report to you during the session. If you have any questions about anything at any time, please don't hesitate to contact us.